All right. Jamie, do students have the right to express controversial political or social views at school, even if those views could be read as demeaning core personal identities? And on a personal note, what happens when I agree with Justice Alito?
Yeah. Well, that reminds me of one of my favorite movies of all time. And I think I've used this quote on this show many times before. Ghostbusters. Mass hysteria. Dogs and cats living together.
Dogs and cats for sure. Yeah, I don't often find myself agreeing with Justice Alito. So this is uncharted territory. It's not. I don't necessarily know if this is a comfortable position to be in for me.
Well, let's work that. This will be your therapy session. We'll work that out.
I appreciate that.
Yeah. So today we're covering a case that made some headlines a while back. A middle school student in Massachusetts wore a shirt that expressed his belief that gender was synonymous with sex, and the school board told him to remove it or go home. The school said it violated their dress code that prohibited hate speech. So today, we're going to dig into the case of LM versus the town of Middleborough, a case that invokes the long-standing Tinker Standard and once again tests the First Amendment in schools. Welcome back to Chalk and Gavel, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, telling the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, Chris, what's our bell ringer or bell ringers?
That's right. Today might be our first all bell ringers episode because we've got a couple. A lot of things are happening and they all relate to things we've already talked about, which is why I wanted to make sure we touched on all of them.
Okay.
So rapid fire. First, the Department of Education has entered into 2 new interagency agreements. So we've talked about this in the past, where part of the Trump administration's strategy for dismantling the Department of Education is to move their functions to other agencies without changing what the agency is responsible for doing. So basically it's a runaround of Congress, right?
Yeah.
And so these 2 new agreements delegate some of the department's responsibilities. So the Department of Education is partnering with the State Department on foreign gifts and contract reporting, so reporting obligations. And they're also partnering with the Department of Health and Human Services, which is a big one that's getting a lot of DOE's responsibilities on family engagement and school support programs. So those are moving over to DHS.
All right. What else?
Let's see. Next up, the Supreme Court in its emergency docket. We've talked about this before. And Jamie, you've mentioned this in a bell ringer or two. Yep. The Supreme Court issued an opinion siding with California parents who are challenging California's law that prohibits schools from notifying parents about a student's gender identity transition at school.
Yeah.
So the court said that religious parents were likely to win their challenge and that the law also might violate parental rights to direct the care and upbringing of their children. Mm-hmm. So this is a big one. We've talked about it before. Schools are basically between a rock and a hard place. If there's a disagreement between how students want to identify and parents' beliefs about what their students ought to be doing. And California said, look, we're not going to get in the middle of it. We're not going to, we're not going to narc on students. Parents, that's your responsibility. And the California Supreme Court said, no, schools, you can't not narc, which is an interesting place to be because now, does that mean they have to narc? Is narc the right word? I don't think narc is the right word.
No, I don't know. I mean, it's just a really complicated place for schools to be. You've got kids who might not want to come out to their parents, but they're struggling, and the school is one of their safe spaces, so to speak. And then So it's just that it's a tricky situation because parent, I think in most cases, lots of parents are going to be very supportive.
Right.
But what happens in those other cases or when the kids are uncomfortable or where, it's just, this is a hard one. So the courts
It's a really hard one with legitimate concerns on every side, right? Like the school, California's law is, more protective of children's rights than
designed
parental
to
rights, right? And that's the kind of the objection that these parents are making.
Yeah.
I think this might be one we have to talk about more in depth. Like this is probably an episode now because of the opinion that the Supreme Court issued on its emergency docket. Like there were dissents, there was there's some big picture ideological struggles that they're having that could have serious implications beyond parental notification policies. So we haven't done this case yet, but
they did so much signaling
exactly
in that emergency docket opinion that it's probably worth an episode.
It is, even though I don't want to cover the emergency docket because it legitimates the fact that they're doing all of this slapdash haphazard without full briefings and they're doing it basically on a emergency basis, right? So it's one of those things where those don't really have precedential effect, but they are in a lot of ways currently very, very strong signals.
Exactly. All right, what else?
Let's see. Speaking of things we've already talked about, a New Hampshire judge announced that, yes, the Trump administration has ended its anti-DEI initiative in K-12 schools. So we talked about how the Trump administration was backing down and not pursuing appeals of where it lost challenges against its February 14th Dear Colleague letter that basically said DEI programs are unlawful, race discrimination. And so the department said they're not going to enforce that letter. That's a win for schools. So the court dismissed that case because the department said this is all moot and the parties agreed. So that's a win for schools. But the Trump administration is still continuing in a lot of different ways to work to curtail DEI initiatives in schools. So while this is one piece of that larger kind of full court press, that there are still lots of other tools and irons in the fire targeting DEI initiatives in K-12 and higher education coming from the Trump administration. So while this is one piece of that puzzle, a lot of that is still ongoing. And then finally, the last one, so maybe this won't be the entire episode, the parties have settled Mahmoud versus Taylor.
Oh, this one we've covered 43 times on this show.
I was going to say, right? It was a busy couple weeks. So, Mahmoud versus Taylor, that was the case where the Supreme Court said that parents were likely to succeed on their challenge against Montgomery County's no opt-out policy based on the parents' sincere religious objections to their children being exposed to LGBT plus inclusive books. And the settlement, interestingly, it included some provisions for how Montgomery County was going to alert parents to the content of course materials. It provided that they were going to provide alternate instructions when parents did opt out, and just kind of some procedural things. But it also included a payment of $1.5 million.
Wow.
From the school to the parents. Now, my guess is most of that is going to cover attorney's fees.
Probably.
Because
taking a case to the Supreme Court requires a lot of attorney hours.
I wouldn't want to receive that bill. Let's just say that.
Wow.
So
$1.5 million.
It was an expensive fight, right?
Yeah. I guess most of them are.
When they get that far, for sure.
Yeah. Okay. Well, that's enough out of you, sir. That's...
I've got more. There's a lot going on.
This is a lot. I'm exhausted.
Oh, good. You want to do the rest of the episode?
You ready to get into this?
I'm really excited for this one. This is one of those ones that makes me really think because it is so complicated and nuanced.
Chris questions his sense of being.
No, I wouldn't say this is an existential crisis, but it did let's say it did require me to stress test some of my ideas about student First Amendment rights. So that's always good.
That's funny. Are you and Alito going out for dinner anytime soon?
He hasn't returned my call. I texted him the other day. I was like,
"You're like, hey bud."
Yeah. Hey bud.
Okay. Well, let's dig back into one of our favorite topics on this show, student free speech. Like we said, Chris is going to have a lot of feelings today, so let's just let's.
You're going to hear me talking through my thoughts. Yeah, I'm going to do a lot of thinking out loud on this.
Yeah, it's a hard one. This is a really tough one. So, a middle school told a student to remove his shirt that said, quote, "There are only two genders," unquote. And they said they had concerns about the impact that it would have on their transgender and gender non-conforming students and the larger school community. So this case hinges on how we understand and apply the Tinker standard that we've talked about so many times on this show. And we've even talked to Mary Beth Tinker herself.
Yeah, episode 50.
Yeah. About how schools may censor student speech if it reasonably forecasts a material and substantial disruption or invades the rights of others. Those are the two sort of Tinker standards, right?
Yeah.
And we've talked a lot about it. So we're going to talk more about it today because this was a pretty recent case, just from a few years ago. And then the Supreme Court recently denied cert.
Right.
So
they said they weren't going to hear this one.
Yeah, exactly. So let's talk about how this went down. So our case starts in the spring of 2023 in Middleborough, Massachusetts. We're heading to John T. Nichols Middle School for this case. It's a traditional middle school serving grades 6 through 8, roughly ages 10 to 14-ish. But before we dive into the facts here, let's talk a little bit about the town of Middleborough.
Oh,
okay. Yeah, context matters, right?
Context is everything, as we're going to talk about throughout this entire episode.
Exactly. So, according to Wikipedia, which
what a
gets
fantastic
everything right
source
all the time, it's in Plymouth County, Massachusetts. I'm guessing that's probably
like the
correct.
Plymouth.
I don't know.
Okay, I would assume.
I guess they have rocks. I don't know if they are the same.
They probably have rocks. The question is whether it's the rock.
The rock, right? So this town has about 24,000 people, so not massive.
Mm-hmm.
And it operates on this open town meeting form of government kind of thing.
They love democracy in those original colonies.
That's right. So that just means that residents vote directly on local laws and ordinances. All right.
Oh, so it's like a direct democracy? I love it. Okay. That's really interesting.
Yeah.
Free speech is really important to that sort of stuff.
Well, ironically...
Oh, yeah?
The town drew quite a bit of national attention a while back over its attempt to regulate public speech.
Oh, well, that's ironic.
Yeah, settle down. I know you like this. So in 2012, residents voted to approve a $20 fine for using profanity in public spaces.
What?
Yeah.
I mean, that's unconstitutional. Like the Supreme Court says, like outside of the school context, because the school context, we've got Bethel versus Frazier that says you can regulate lewd and indecent speech, but like obscene speech outside of the school context is not prescribable under the First Amendment. Like, because there's a famous case where someone wore a jacket that said, F the draft, but actually used the real word, and the Supreme Court was like, meh, that's fine.
That's fine. Yeah, exactly. Well, listen, it only applied to public spaces. It's a good thing that it didn't apply to private spaces, because if I lived up there, I'd be broke. So anyway, the Attorney General felt similarly to how you felt, Chris, and said that law violated the Constitution, and blocked the law, and then the town backed down. Okay.
So this is an interesting place with a complicated relationship with free speech.
Yeah,
let's say.
That's a little context for you all. So
interesting.
Another fun fact: the town of Middleborough is also known as the cranberry capital of the world.
Wow!
Look at that.
That is a fun fact.
It is. It's irrelevant to this case, but it's fun. It's fun. Cranberries. Okay.
Huh.
Okay.
So not rocks. Cranberries.
Cranberries. Okay. So according to the court opinion, the school was aware that it had LGBTQ plus students. Okay. The interim principal at the time, Heather Tucker, she had experience working with kids who had been bullied because of their gender identity. She had also worked with kids who had engaged in self-harm or contemplated suicide. Okay, so we're providing you with a little bit of background here and context for, that's good to understand, when we talk about how everything went down in this case.
Right. Yeah. Because context is everything.
Exactly.
Like many schools, these are persistent issues.
Yeah.
Particularly for LGBTQ plus students. Like we know that there's national trends where they are more susceptible to being bullied, to harassed, higher rates of self-harm, suicide ideations.
These are big issues. They've been
big issues.
Just, issues of suicide and self-harm and all that stuff have increased exponentially among kids. And a lot of that, not all of it, but a lot of it is tied to gender identity issues and those kinds of things. Anyway.
Right.
So it's important to note here too, that the superintendent was also aware that some students in that school in recent years had fallen into these sort of bullied and suicidal ideation kind of categories. And in many cases, those were due to their gender identity. So very similar in this school context to sort of the larger national trends.
Right. But they're aware of it, not just that these are happening outside of the school, but they're also happening in the school. Okay.
Yeah. So in June 2022, the district collected a student survey. I'm not really sure what the survey was about exactly, but in that survey, they had over 20 comments submitted by students that referenced perceived bullying, feelings of unwelcomeness, and other concerns about how the LGBTQ plus community was being treated. Okay. So not only are they aware of these issues, the students are acutely
expressing them,
aware and expressing that.
Okay.
And a few other pieces of information to kind of round out the context here. So the school had a gay straight alliance club that met monthly for LGBTQ plus students and their allies. And attendance in this club was about 20 students or so.
Okay.
The school also had a dress code in its handbook, as most schools do, that emphasized health, safety, and appropriateness. Okay. Not that uncommon. That's a pretty common thing.
Yeah.
It also mentioned that clothing that caused distractions or inhibited learning wasn't allowed. Okay. Very common.
Sure.
But, it's always important here. Schools really have to be careful. Okay. Because we've talked a lot about how something that might be offensive to somebody might not necessarily rise to a sort of Tinker Standard disruption level event. Right. And so when you have policies that say, clothing that causes distractions or inhibits learning, like you've got a Tinker Standard bar that you have to achieve there.
If the clothing is expressive.
If it's expressive. Right.
Right. And that's a thing that courts have kind of grappled with. And they've said that like clothing that doesn't have like messages or words isn't necessarily expressive. So it doesn't necessarily fall under Tinker. Yeah. So if you've got something that just says like, hey, nobody can wear spaghetti straps, like that's not going to implicate Tinker. But if it said like, maybe there's a prohibition on hate speech.
Or if it was language that said prohibiting spaghetti straps is sexist. But it wasn't.
I don't think the language would say that.
But no. But if you wore a T-shirt that said prohibiting, right, prohibiting spaghetti straps.
So I can't wear spaghetti straps.
You do you, man. Okay. So anyway, here this is the big thing about the dress code. It also said that clothing must not. This is a quote here. Clothing must not state, imply, or depict hate speech or imagery that targets groups based on race, ethnicity, gender, sexual orientation, gender identity, religious affiliation, or any other classification, and any other apparel that the administration determines to be unacceptable to our community standards will not be allowed. Well, that's quite a lot, sir.
Right. The first part, I don't have that big of a problem because like hate speech, right? Like,
yeah.
And, hate speech or imagery is still expressive, and it has to be targeted at specific groups. Like that all seems defensible.
Yes.
That second thing, any apparel that the administration deems to be unacceptable to community standards, like that is the
That's the
quintessential definition of a squishy standard. Like, what does that
and
mean?
other duties as assigned.
Right, yeah. And whatever else I say you can't wear. Like, that doesn't mean anything.
No. Anyway, there's the context. That's the background for you. Okay. So here's what happened. On March 21st, 2023, we have a student, LM, and he wore a shirt that said, quote, "There are only two genders," unquote. He knew that his school didn't feel that way, so he wore the shirt to express his own views on the topic. Expressive speech. There you go, Chris.
Right. Yep.
And according to the court opinion, he wore it to also express that those views were not, quote, "inherently hateful."
Okay.
Okay.
Part of the issue here is like LM in some way was speaking back to the school's speech.
Yes.
And I think there were allegations, and this isn't a big part of the opinion because they kind of sidestepped this viewpoint issue.
Right.
But like there were implications that, you know, the school had been taking affirmative steps to be more inclusive to LGBTQ plus individuals.
Yeah.
And so this was LM kind of like, you know,
saying, okay,
expressing his
you all
view
believe
on that same topic, right?
Yeah. You believe that. I don't. And I'm going to say that I believe this.
Right.
So, okay. So he wears this shirt and he goes to first period, and the teacher saw the shirt and contacted the assistant principal.
In the first period. So like we are at the very beginning of the school day.
Yep. Teacher called the AP, expressed concerns that the shirt might cause a physical safety issue for LM, as well as other students who could be affected by that shirt.
Okay.
Okay.
So the teacher is worried about how students are going to react to LM.
Yeah.
Interesting. Okay.
Yeah. The AP reaches out to Principal Tucker, who went to the class to talk with LM and the teacher. Okay. Tucker told LM that he could not wear the shirt, so he needs to remove it, or he also has the option to discuss the matter further. So get rid of the shirt, or we can talk about this.
In my office.
Yeah. And so
I'm guessing.
LM said, well, I'm not taking the shirt off, so let's go have a conversation.
Cool.
Maybe he's trying to exercise his First Amendment rights.
Hey, I do see some similarities between LM and
Bong Hits for
Frederick.
Jesus.
Yeah.
So LM was much younger, though, than Frederick. Anyway, so off to another room they went with the principal and the school counselor. Tucker said that some students complained about the shirt, so he had to remove it before going back to class. LM said nope, and Tucker called Dad.
And Tucker's the principal, right?
Tucker's the principal, yeah. Okay. Dad supported his son and came to pick him up.
Oh,
yeah.
I see. Like this is one of those great examples of like students, parents, school, like, and just how that's such a complicated dynamic here.
Yeah. Yes. Now, at this point, the school says, there's no formal discipline happening here.
Right, because Dad just picked him up.
Dad just came and picked him up from school. Well, okay. Let's pause for a second here, sir.
Wait, where did I put my soapbox? Jamie, you want to borrow it?
Yes, I will take it.
Okay.
Just for a minute. I'll give it back when I'm done, I promise.
Okay, great.
Okay. You just a little piece of advice, schools out there. You can't tell somebody that, in this case, for example, you have to remove that shirt or you can't go back to class unless you do that. And you can't say that and say, but this is not discipline. We're not formally writing him up or whatever. You can't prevent somebody from accessing their education. That's discipline. Whether you write it up or not, it's discipline.
Right. It wasn't a parent just picking their kid up from school. They picked their kid up from school because you said
they can't go back to class.
Right.
Right. So like, what else are you going to do? So like, and listen, we're kind of making light of this, but we're also not, because this stuff happens in schools all the time and it's dangerous territory. Okay. If you don't write somebody up for something that is clearly discipline, you can't just say it's not discipline because you didn't write it up. If it walks like a duck,
hey,
right? Maybe we should put that on some merch.
We should.
We didn't coin the phrase. We just use it quite often.
If it walks like a duck, quacks like a duck, then it's probably a
illegal
violation of your constitutional rights.
That's funny. Okay. So,
right, yeah, because it's a due process issue, you know, from the legal perspective, right? Like, if you say this isn't punishment, but there's still a negative consequence attached to it, like, and we see this all the time in special education. It's a huge issue where, you know, schools are struggling or not able to kind of like meet students' needs, and so parents will come and pick their kiddos up from school when situations happen, and they don't get marked as absences. They don't get marked as in-school suspension, out-of-school suspension, or anything like that. So, like, you know, it denies in some situations that free and appropriate public education. And, you know, the same is true for, you know, all students, right? Yeah. So, like, you know, just because you didn't write it up as a suspension or as a formal discipline, like the court here at least doesn't even acknowledge that argument. They're like, you know, this is enough to make out a First Amendment claim, even if you didn't call it a formal punishment.
Right. Now, this is not a direct, perfect link here, but I'm going to use the quote anyway, just because I love the movie and it's fun, and this is what I'm thinking about.
Is it Ghostbusters again?
No, it's not Ghostbusters. Okay. This time it's The Princess Bride.
One of my all-time favorites.
Oh, yeah. Just like fantastic when Mandy Patinkin is like, you keep using this word. I don't think it means what you think it means.
I think I've quoted that exact line on this podcast. Yeah.
Oh, great movie. Okay. Anyway, so just to recap here, kid refuses to take the shirt off. Dad comes, picks him up, takes him home. Fast forward about a week and a half later, and an LM's dad emails the superintendent asking for an explanation. He mentioned that the shirt. Well, you have.
Oh, I'm going to have something.
Thoughts,
so
sir?
The week and a half.
Yeah.
That as a school leader, like my alarm bells are going off.
Well, because speaking of walking and talking like a duck, he's getting them in a row.
Well, right. And like, why did he wait a week and a half if this was so important? Oh, it's probably because he was getting an attorney, and everything I'm saying now is building a case.
Yeah. He's getting his ducks in a row.
Right.
Anyway.
Yeah. And also that goes back to another wonderful piece of Chalk and Gavel isms. Dance like no one's watching. Email like it's going to be read on Chalk and Gavel.
Yeah. So in that email, he mentioned that the shirt was essentially political speech. Okay.
Agreed.
And he didn't target any particular person. Okay. So it sounds like he's read the policy.
Right. Yeah. Because the policy says what? Hate speech directed or targeting at a group of people, though. Yeah. Right.
And he's not calling it hate speech. He's calling it political speech, which the courts have clearly identified as very protected.
The core of First Amendment protections, right? Yeah.
Yeah. A few days after that, the superintendent emails back and said that LM hadn't been disciplined, again, if it's walking like a duck, but the shirt, in the school's view and in referencing the dress code, contained a message that targeted students of a protected class, namely in the area of gender identity. Okay. Now, this was all before the Supreme Court discussions about whether or not gender identity actually is a protected class, but that's for another episode, probably over the summer.
Right.
When we talk about that case.
Yeah. So that's the transgender student athlete case, but I don't think they're going to go that route.
No,
we'll
think so.
We'll see.
I don't think so. Okay. Anyway.
But it took the superintendent a few days to respond, hopefully because they were talking to their attorneys.
Yes, exactly.
Attorneys are involved.
Yeah. You always get concerned. You always get the red flag thing when, it says the email came in at 3:52 and a response at 3:55, right? Like, oh, you did not, maybe you didn't think hard enough before you responded, but
yeah.
Okay. So, a few weeks after that, Dad's attorney comes in.
There he is.
Okay. Dad's attorney. Yeah. Sends a letter to the superintendent stating, yep, you guessed it, LM's free speech rights had been violated, and also threw in there that the dress code's prohibition on hate speech was unconstitutional. Well,
probably because it's vague and overbroad.
Okay.
Or at least the community standards one.
Yeah.
Right?
Yeah, exactly. That last part of the dress code that we read before. Okay. So now I think now is probably a good time, Chris. We have the audio thanks to one of our wonderful research assistants, not one, the only.
I was going to say.
The Chalk and Gavel research assistant.
Thank you, Andrea.
Andrea. Yeah, thank you. So we have the audio and video, if you're watching this, of LM's speech to the school board. Okay.
Right.
All
Okay.
right. So
yeah, because at this point, the situation is not just like, this is kind of taken on a life of its own, as these often do, where now like other, local news is involved. I think this got national attention at the time. Like, this is now a political issue.
Yes.
And so LM is speaking to the school board about this political issue.
yeah, let's hear from him.
I appreciate that we're hearing from the student. I love it.
Middle school. I appreciate the opportunity to speak to you today. I never thought that the shirt I wore to school on March 21st would lead me to speak with you today. On that Tuesday morning, I was taken out of gym class to sit down with two adults for what turned out to be a very uncomfortable talk. Yeah. I was told that people were complaining about the words on my shirt, that my shirt was making some students feel unsafe. Yes, words on a shirt made people feel unsafe. They told me that I wasn't in trouble, but it sure felt like I was.
That point. Yeah,
there it
that
is.
we talked about.
I was told that I would need to remove my shirt before I could return to class. When I nicely told them that I didn't want to do that, they called my father. Thankfully, my dad supported my decisions and came to pick me up. What did my shirt say? 5 simple words. There are only 2 genders. Nothing harmful, nothing threatening, just a statement I believe to be a fact. I have been told that my shirt was targeting a protected class. Who is this protected class? Are their feelings more important than my rights?
Ooh, that's
I don't complain
interesting.
when I see pride flags and diversity posters hung throughout the school. Do you know why? Because others have a right to their beliefs just as I do. Not one person, staff, or student told me that they were bothered by what I was wearing. Actually, just the opposite. Several kids told me that they supported my actions and that they wanted one too.
So that's really
I
interesting.
experienced
Because, it's substantial disruption, right? Like that's the standard.
That's the Tinker standard. Yep.
He's saying that there basically wasn't any. And also the message, that rhetorical question he asked about whether or not, this protecting this group is more important than his rights. Like, to me, that's kind of like,
that's
at
the fundamental
heart of this case, right?
Yeah.
But the viewpoint thing that he just pointed out, like, hey, there's pride flags, there's these other things in the school. You said what you wanted to say. Why can't I say what I want to say? Yeah. So, kudos to this kiddo.
Yeah. And you know what? Also too, like, I'm just side note here, a middle school kid going to a school board meeting and standing up in front of an entire school board.
Right. And look at where the
like,
microphone is.
Yeah.
Like, it's taller than he is.
Yeah. This is like, there's some guts there.
Oh yeah, for sure.
And that's not an easy thing to do. It's not an easy thing to do for some adults.
For sure.
Anyway, let's keep listening to him.
Yeah.
I was told that the shirt was a disruption to learning. No one got up and stormed out of class. No one burst into tears. I'm sure I would have noticed if they had. I experience disruptions to my learning every day. Kids acting out in class are a disruption, yet nothing is done. Why do the rules apply to one, yet not another? I feel like these adults were telling me that it wasn't okay for me to have an opposing view. Their arguments were weak, in my opinion. I didn't go to school that day to hurt feelings or cause trouble. I have learned a lot from this experience. I learned that a lot of other students share my view. I learned that adults don't always do the right thing or make the right decisions. I know that I have a right to wear a shirt with those 5 words. Even at 12 years old, I have my own political opinions, and I have a right to express those opinions. Even at school, this right is called the First Amendment to the Constitution. My hope in being here tonight is to bring the school committee's attention to this issue. I hope that you will speak up for the rest of us so we can express ourselves without being pulled out of class. Next time, it may not only be me. There might be more students that decide to speak out. Thank you for your time and good night.
Wow. Good for him. Yeah. Like the courage that took, and, well spoken, he was reading his remarks, like,
yeah.
And that's kind of one thing that I often say in these cases is like, these are such teachable moments. Right. And like, he was talking about what he's learned from this. Right. And like, I don't know if he learned the messages that I want the First Amendment to teach.
Right.
The activity of engaging in this kind of civic discourse like that itself is such a fantastic learning opportunity. It's this situation isn't the best, but like,
yeah, but there's some significant learning taking place here.
For sure.
Yeah. But that's not where it ended.
No, they didn't hear that impassioned speech and immediately say, you know what, we were wrong.
No, they didn't do anything of the sort. So about a week after Dad sends the attorney's letter to the superintendent, LM goes back to school wearing the same shirt.
Oh,
yeah,
and
but there's a twist.
He did it. Oh, good. I love twists.
There's a twist.
But he did it because the letter from the attorney, if I remember this correctly, the letter said LM is going to wear this shirt again to school.
Oh, yeah. Right.
And it basically dared the school to censor it a second time.
You do something about it. I dare you. Yeah.
Which, as an attorney, like that attorney is just building their case because it's basically a rock and a hard place, or like damned if you do, damned if you don't for the school. Because if they punish LM again, now they've got two harms. Yeah. And if they don't punish him, well, now you've got like inconsistency. And so that even undermines their case even more for like, is it actually disruptive or not? Right. So like, that the sending him back in the shirt is such a strategic choice.
Yeah. But you want to know what the twist was?
What's the twist?
So he wears the shirt, but he covers up the two words that say only two and covered him up with tape. And on the tape, he wrote censored. So the shirt said there are censored genders.
I kind of love that.
Yeah. So he was making a statement about his belief, and then he was also making a statement about what the school was doing to his free speech rights.
About the censorship, right?
Yeah. So the school, in that case, said, no, that doesn't count. That's still
the same issue.
The same message.
The other one. Yeah.
And so they said, you can't wear that. And anyway, just to kind of wrap this piece up, there were a couple other students who wore the exact same shirt after that. And they were told the same thing by the school, get rid of it. You can't go back to class unless you take the shirt off. One did, the other one didn't. Neither were officially disciplined. So anyway, there's the story. Now what?
Wouldn't you know it?
Justice Alito called you and said, Chris, what's your what are your thoughts?
That hasn't happened yet. I'm still holding out hope. We'll see. But LM brought this lawsuit, right? Mm-hmm. And eventually Justice Alito will say something about it, but not yet because we're at the trial court. And LM is arguing here that the school violated his First and 14th Amendment rights when it forbade him from wearing his shirts. So under Tinker, he argued that the school violated the First Amendment and his rights to free speech, as he said in his speech, because there was no evidence that his shirt caused or would have caused a material and substantial disruption, or that it invaded the rights of others. He also argued that the school was engaging in impermissible viewpoint discrimination because it was censoring his views about gender while simultaneously allowing and even promoting LGBTQ plus inclusivity at the school. Mm-hmm. And then finally, the 14th Amendment issue and First Amendment issues around vagueness and overbroadness for the school dress code policy. Okay. So those are all of his claims.
Okay.
And now this is where things get interesting from a legal perspective. No one here, the school or LM, is arguing that there was actually a material substantial disruption. They're not saying that like it had already happened, right? All of this is looking forward to predict whether or not a material and substantial disruption was going to happen.
Now, the courts have said in the past, that's okay. It's okay to restrain speech if you have a really good reason, right?
If you reasonably forecast that there will be, basically you don't have to wait for the bad thing to happen to prevent the bad thing from happening, right?
Yes.
But here's the interesting wrinkle. The school is arguing that, they do have an argument that like, yes, there would have been disruption to the like operations of the school because we're worried about how students were going to respond to LM, but that's not the core of their argument. The core of their argument is that the negative impact on students based on this shirt and the message that there are only two genders, that would have basically had such a profound psychological impact on some students that it would have, quote, poisoned the educational atmosphere.
Wow.
So basically, they're looking at the impacts on students and how they experience the speech to then say that is a material and substantial disruption. So a lot of this actually comes down to, how do we understand that phrase, material and substantial disruption? Is it just like the operations of the school, or is it like the sound
changing the culture?
Changing the culture, right?
In a way that makes it hard for us to carry out our mission. That's big.
And that would to kind of jump ahead a little bit, but that's one of Alito's critiques of this decision, is that it expands that term of what constitutes a material and substantial disruption.
Yeah.
Because in the Tinker case, they're talking primarily about
the teachers
disrupting
not being able
the operation.
to teach.
Yeah, exactly. Not necessarily like these more bigger picture things about like, making students less likely to come to school, less feel unsafe, not be able to like focus on their learning, those sorts of things.
Yeah.
But this all comes through in how the court is framing the question. Essentially, the court is saying, like, when do First Amendment rights, students' First Amendment rights, have to give way to school authority to stop speech that demeans people based on their core characteristics like race, sex, religion, sexual orientation?
Okay, so on one hand, they're saying the schools have this obligation to regulate speech that targets and demeans groups of people. But there's also a First Amendment thing, and
how do we balance?
How do we
those
reconcile?
two? Right.
Okay.
And, Tinker kind of gives us two ways to answer that question.
Okay.
Right. Because this is all falling under Tinker, because this is, it doesn't fall into any of our other exceptions. So Tinker is kind of the big umbrella. And so Tinker has two prongs, right? It's got the material and substantial disruption prong, and it's got the rights of others prong.
Yep.
This seems to fit in both of those, right?
Yeah.
So speech that is targeted at specific individuals or groups and that's so severe that it denies them access to education, like that seems like a really strong fit for the invades the rights of others, because it denies them access to education. And that's essentially how courts have handled like Title IX, bullying and harassment, sexual harassment stuff. Like if it's so severe and pervasive based on sex, a core characteristic, and it denies educational access, schools can be liable for failing to address it. And so, there's kind of a connect, or like a logical like comparison there between the rights of other prong and that Title IX standard.
Okay.
And the Supreme Court recently in the Brandy Levy versus Mahanoy case said that schools can address severe bullying and harassment consistent with the First Amendment. That was actually one of their green lights, right? When we talked about that case, schools can step in to address bullying and harassment, even if it occurs off campus, because that's, part of like, the
violating rights of others. Yeah.
And they didn't put it under that rubric, right? But they did say that you can address,
you can do it. Yeah.
Those types of speech.
Yeah.
So is that the route the court took? So the lower court said like, yeah, look, this isn't easy. This is slam dunk. School was fine because they enforced the dress code to protect against the invasion of the rights of other students.
Okay.
Essentially, like this was, demeaning. It denied the identities and existence of transgender and gender non-conforming students, and that could have a profound psychological effect. We've talked about it already, about kind of like, the potential impact that this kind of speech has on those populations and, the unique experiences that those populations go through. For the court, that was enough to say, school, you were fine.
So they're kind of putting it under that umbrella of violating the rights of others,
right?
Kind of thing. Yeah.
Right.
Yeah.
And LM didn't necessarily like that decision. So LM appealed it to the First Circuit Court of Appeals, and they came to the opposite conclusion, not about who wins. They still found for the school,
just for a different
reason.
But
they put it under the material and substantial disruption bucket because there's not a lot of case law on the invades the rights of others prong. Most of the Tinker stuff is on material and substantial disruption, but the First Circuit synthesized a test under material and substantial disruption that helps them address, or that they apply to address these situations where speech could be seen as demeaning groups based on core characteristics. Okay. So they've got a 2-prong test inside of Tinker's 2-prong test. You ready?
Give it to me.
All right. So they say that schools may bar expression by students that target no specific student if two things you have to meet. One, the expression is reasonably interpreted to demean one of those core characteristics.
Okay.
And two, the demeaning message is reasonably forecasted to, quote, poison the educational atmosphere due to the severe and serious negative psychological impact on students with the demeaned characteristic.
Wow. Okay. So they're going for that big, broad, affecting school culture, climate.
Right. Yeah. Like attendance, academic success, all of those things. So in a lot of ways, this is it's a much broader understanding of Tinker. And it's also, it's more vague for sure.
I was going to say it's a lot more subjective.
It is a lot more subjective. Yeah. It's more subjective. It's more permissible. Like there's two reasonables in this thing.
Yeah.
Reasonably interpreted to demean and reasonably forecasted to poison the educational atmosphere. So like it defers a lot to the educational judgment of educators.
Yeah. Yeah.
So yeah, like there's a lot to unpack with that standard. But why don't we do some examples? What do you say, Jamie?
Let's do some examples.
You want to do a pop quiz?
Okay.
Got a pop quiz for you.
Okay. Bring it on.
This two-factor test is the First Circuit's attempt to kind of synthesize the case law on this issue that they found. And so I've got some examples from previous cases, and I want to see how good the First Circuit's test is in predicting the outcome of those cases.
Okay.
So, Jamie, I've got the T-shirts that people got in trouble for wearing.
Okay.
And I want you to tell me who won, the school or the student.
If we apply this,
if we apply the
standard,
like, reasonably demeans a group of people based on a core characteristic and, has the potential
to
or reasonably
poison
the environment. Yep.
Okay.
So are you ready? Here we go. First one.
Yeah.
The T-shirt said, homosexuality is shameful.
Okay. So under the new test, the school wins.
School wins?
Yeah. Barring the shirt.
Barring the shirt. Yeah.
Yeah.
Yeah. So yeah, in all of these situations, the school barred the shirt and the student challenged that.
Okay. So under this new test, homosexuality is shameful, shirt, school wins.
And you are correct.
Hey.
What about a shirt with an image of the Confederate flag?
Oh, this one has been a very interesting one.
This one's complicated.
That was
because of the complicated history of
South Carolina, right? I think
there's
a bunch of cases.
Dozens of these cases. Yeah.
Yeah. Okay. So that one, is it targeting a particular group? Reasonably targeting a particular group? Or groups? I think one could possibly argue that. And is it going to poison the atmosphere? I think they could probably argue that as well.
Yes, and that is why schools will often win that one.
Yep.
So the answer to that one is actually it depends, because courts have gone either way depending on the context.
Yeah.
But in a number of examples, schools have won for exactly what you just said about, like, especially if the school has a history of racial tensions.
Yeah.
Right?
Okay.
All right. What about this one? Be happy, not gay.
Yeah. I mean, I think for the same reasons, the school would win that one too under these standards.
Except the student won that case.
No, but you were asking me if it would win under the new First Circuit.
Right, but the First Circuit is saying that their standard is consistent with these prior case laws.
Oh, but what I'm saying is if you're telling me that they didn't win that case, then it's not.
Which is a problem with the standard.
Exactly.
Yeah.
Exactly.
Right.
Okay.
So in that case, the court said that it was, identify students based on a core identity, but it's not severe enough. Like it's
to poison
too trivial of a statement
to disrupt.
Right.
Okay.
Yeah.
Okay.
So it's a line drawing issue, right?
Okay.
What about a T-shirt of Jeff Foxworthy quotes about you might be a redneck if?
Okay. Well, first of all, I just have to pause and say, I was a kid in the 80s and late 80s, early 90s when the Jeff Foxworthy stuff was like the height of pop culture.
Right. Yeah.
And I found a lot of that as a kid incredibly funny.
Yeah.
What
was the comedy tour they did with him and Larry the Cable Guy?
Yeah.
Right.
Anyway, okay. So under those First Circuit standards, I would say, would it be enough to poison the atmosphere?
Right. Or does it target
a particular group?
Or demean a particular group? Yeah.
I don't know if I don't know if you would consider a redneck a particular protected class. Right.
Could be a group. Yeah.
But it could be. And so I would say that, that should fall under the First Circuit's.
Is it severe enough?
Is it severe enough? I don't know.
And the court said no. Student won that one.
Okay.
Because it was not enough to essentially like poison the environment, right? The potential harm to the students wasn't severe based on what it said.
I do also want to mention too, like these courts in those cases were not applying that standard, even though they were talking about similar
This
issues.
is the First Circuit saying, we synthesized these cases and this is the rule we came up with.
Right. Okay. So what's the last one?
The last one is probably the easiest one. The shirt said Islam is the devil.
Okay. So that's a problem. So
that one I think is probably the furthest along the line of like, it identifies a particular group based on religion. And sorry, I kind of gave you the answer to that one. I guess
but I think the point
you didn't do very good. I think you only got a 60%.
No, but I was applying the First Circuit's thing. And I think I was trying to prove the point that you're trying to make here is that the First Circuit used those cases to say, see, this is why our new test that we've developed is good. And what I'm telling you is by the answers that I gave, it's not like they didn't
because
really...
it is overbroad and open to interpretation. Right.
Right. Exactly.
So I can be right and you can tell me I'm right and you can still be wrong. That's fine. No, I completely agree with your point. The
point is it's not a good test.
I don't know if it's not a good test.
It's not a precise enough test.
It's not precise, right? Yeah. Because it does acknowledge a lot of things that I think are really, really important in the school context, right?
100%.
And that's why I struggle with this case so much because I want to, promote student-free speech, but I also recognize that like students have to go to school, right? And they bring themselves to school and their identities. And we need to make sure schools are a safe place for everyone. And they need to be affirming. They need to, be free from bullying, harassment, intimidation, all of these different things based on those core identities.
Right. And we have to acknowledge the fact that if we just let anybody say whatever they want anytime, it's going to significantly affect not just individuals or groups, but it's going to affect the overall culture and climate of a school. And we know without a doubt, the research has pointed very, very clearly towards the fact that schools with healthy, positive, inclusive cultures and climates, where people feel valued and respected, those schools have much better outcomes than schools that are filled with these tensions and because that makes it very hard to learn. A bad culture, a bad climate is bad for everybody. And so I also don't want to say that this is like, I don't want to say this is a bad test. I think the aims of the test are important, but the precision is lacking from a legal standpoint.
Right. And you can see what they're doing here, right? They are connecting the dots between material and substantial disruption to the school environment as a whole to this one little thing that if it balloons, maybe could have that bigger impact. Which there's a causation issue, right? Did that one shirt could it really cause that bigger thing? But if you have to allow one shirt, then maybe you have to allow all these other shirts too, right? Right. I think it's too permissive in a way because it allows the school to make a lot of these judgments. Yeah. This is why I mentioned agreeing with Alito, because these are all points that Alito makes in his dissent from the Supreme Court's decision not to take this case.
Right. And when you give the schools the ability to really make all those kinds of judgments, that's when you run into these kinds of problems where they are sort of disproportionately their decisions are disproportionately affecting one belief over another. And that's one of the reasons why we've talked about on the show before, like, if you're going to suppress speech, you've got to make sure that you're not doing viewpoint discrimination, that you're that you're violating everybody's rights equally. I mean, I make fun of it. That's not that's not what I mean. But
you're not violating anyone's rights.
You can't tell somebody you can't wear a Trump shirt and those people can wear a Biden shirt. You can't do that.
Well, and that's really interesting because the court here. So, the court looked at the two gender shirt and said it was reasonable for the school to conclude that demeaned a group of people, and that was, the potential psychological impacts of that were so severe that it would poison the school environment. So the school looked at this shirt and said, because of what it said, because of the core identity of gender, because it's so severe to deny someone's very existence, because we're dealing with young children, like it's a captive audience, it's a t-shirt, it's ongoing, like all of those reasons show that this could have a very severe impact. And so, yes, it demeans, yes, it could poison the environment. So the court said, based on our new test that we articulated, the school's actions did not violate the Constitution. But to your point about viewpoint discrimination, the court didn't address it. They essentially said that Tinker doesn't incorporate prohibitions on viewpoint discrimination. All Tinker cares about is whether or not there's a substantial disruption.
Okay.
And so the court here, the First Circuit, doesn't address LM's argument that this is viewpoint discrimination. They basically said, like, that's neither here nor there.
Okay.
Yeah.
That's fascinating.
Yeah, it is. And that, I think, is one of the big challenges, I think. And that's actually an open question within Tinker. Lots of courts have looked at that and come to different conclusions on whether or not Tinker incorporates viewpoint discrimination concerns or not.
Okay.
I think it does, but it's still a really complicated question.
Right.
Because, you've got situations where, like, one viewpoint is really controversial and could have a very substantial disruption, but the other viewpoint is widely accepted and wouldn't have a disruption.
Yeah.
Right. And so, like, you're only punishing disruptive speech, but within that you can't discriminate. But, like, what if the one viewpoint isn't disruptive? And that's where I think a lot of the struggle comes here, because like the school was, if you accept that the school was promoting a viewpoint about LGBTQ plus inclusivity, like that wasn't disruptive in the same way, potentially, though maybe you could make the same argument that it was disruptive in the same way as LM's shirt.
Yeah.
And so, like, I think it's a really complicated question, and the court here just doesn't address it in much the same way that they don't really fully engage with LM's vagueness and overbreadth challenge. They just kind of say, like, this is a fine policy. We kind of defer to schools in drafting their policies. They don't have to be as precise as, like, say, a criminal code.
But we keep talking about what Alito said, and we know this case did not go to the Supreme Court, or at least they didn't take it up.
Right.
So where does Alito come in all this?
Yeah. So LM loses at the trial court. He loses again at the Court of Appeals. And so he appeals it to the Supreme Court. The Supreme Court looked at this and decided not to take up the case. So in order for the Supreme Court to take up a case, you have to have, I think it's 4 of the 9 justices vote to take up the case. And here they apparently didn't get 4 votes. They got 2 to take up the case, though.
Oh, I'm going to guess.
You want to guess who?
I'm going to guess it was Alito and Thomas.
Hey, how'd you know? Alito and Thomas dissented from the decision not to take up the case, and they both wrote separate opinions about
which doesn't always happen, right? When they don't take up cases, they often just don't take up a case, and you have no idea why they're not taking up a case.
Right. And this is also really interesting because we've talked about the Alito cheat sheet before.
Yeah.
You remember in the TJ selective admissions case, right? Yeah. Alito dissented from a denial of cert, basically laying out like, hey, I know we're not taking up this case. I think we should. And here's how I would think about it. And it basically
He's giving a roadmap,
right?
Future cases.
Yeah. And so that's kind of what this is. So Thomas and Alito both wrote separate opinions. Thomas wrote an opinion just for himself. It's only about a page long, where he basically says, Tinker is wrong. It was wrongly decided. And the First Amendment has nothing to do with student speech. He's made this case. He's made that argument before. it is what it is.
Rather successful.
Based on history and tradition.
Yeah.
All right. I don't ascribe to it. Luckily, Thomas is just writing for himself. Alito, though, wrote an opinion joined by Thomas. So this is a two-justice dissent, where he argued that the court should have taken the case up because he wanted the opportunity to affirm that Tinker says that schools can't engage in viewpoint discrimination when regulating student speech. And he also thought that the First Circuit's standard, its demean test, was too permissive. It offered an overly broad interpretation of what constitutes a material and substantial disruption. And he also said it completely abdicated the role of the judiciary in protecting students' rights because it was too deferential to schools. And, that echoes a lot of kind of what we've said. And, it's one of those situations where, like, I think it's a really hard situation, like, because, it is a conflict between very, very significant interests. And there's also this question of deference and who should make these decisions. Should it be courts who aren't in the thick of it, or should it be school officials who are, in the context? And then, that question about viewpoint discrimination, I think, is also really interesting. You can't engage in viewpoint discrimination within categories of speech that you can prohibit. So, like, the courts have said that, like, you can punish fighting words, which are like words that would have the immediate effect of like a breach of the peace. But you can't prohibit fighting words that only prohibit fighting words directed at, say, Protestants, for example. That would be impermissible viewpoint discrimination, because even within these categories, you can't engage in viewpoint discrimination. Mm-hmm. But if Tinker says that you can prohibit material and substantial disruptive speech, that means within that category, you can't engage in viewpoint discrimination. But what if one of the sides doesn't have a disruptive impact?
Exactly.
And that I think is like,
what if you are in a community where 99% of the people believe something one way, right? That viewpoint being expressed is not going to have any kind of material or substantial disruption.
Right. And could you silence the other viewpoint then?
Yeah.
Because it would be disruptive. Mm-hmm. And I think like that's a question that I don't think Tinker answers.
No.
We've seen courts who have said that basically, like, if your intent is to engage in viewpoint discrimination, that's obviously problematic, right? Like, but yeah, there's, I think it's a question that the courts are going to have to grapple with. And, maybe they should have taken up this case to grapple with that. They've taken up a couple other education cases, so maybe
that they probably
exhausted.
Shouldn't have grappled with, but that's okay.
Yeah, maybe. So, I think it is interesting, but this is, the LM's demean test is now the law of the land, at least for the First Circuit. And so we'll have to see what happens, because the Supreme Court, despite Alito's objection, didn't take up the case.
But if another case comes along, one side
there's always going to be another case.
Yeah, there's always going to be another case, and one side in that case is going to look very closely at what Alito said.
Right.
Because he's painted them a roadmap.
Well, and I think other courts are going to look very closely when they're looking at whether or not to use the First Circuit's standard and like allow that to influence other decisions outside of the First Circuit. People are going to look at Alito and be like, "Ooh, I don't know."
This is fascinating stuff, man. People need to pay more attention to education law.
Like, I mean,
like that's
not
us, because that's all we do. But
it's exhausting sometimes.
It is very exhausting.
The last thing I'll say about this case, going back to my comment about it being educational, there are so many different ways that the school could have responded to LM's shirt.
Yeah. That
didn't punish or censor the shirt. And if they're concerned about how students are going to respond to that, then, I almost think it would advance their interests more if the school talked more.
Yeah. Facilitate more dialogue. Yeah.
Yeah. Rather than censor LM, tell those students how much you value them and basically meet LM's speech with more speech. Right. And that's kind of the bottom line, like, that I often go back to is like, we want conversation, not censorship.
Yeah. And listen, oftentimes it's an easier decision.
It's quicker. It's simpler.
Quicker, simpler, especially if you're in a community where 99%, and I'm not saying this community was 99%, but like, if you're in a community that is dominated by a particular viewpoint it's oftentimes quicker and easier to take a position that placates the majority that has that dominant viewpoint, right? And that is often not the best course of action from a legal standpoint, but it's also not the best course of action from a learning standpoint.
Right.
Right. And learning, especially the really good, meaningful kind, is hard.
Right.
And
it can also be uncomfortable.
Uncomfortable and hard. And listen, that's often where the majority of growth occurs, is out of discomfort. So, yeah, I mean, there's a lot of takeaways. I think we've covered most of them in here. Definitely don't just say it's not discipline when it's actually discipline. That's
right.
Nice try.
I think we found another pet peeve.
Yeah, like it's the answer to speech you don't like is more speech.
Here.
And it's respectful speech. Like that's the other really important thing.
That's key too, right?
Like,
because there is a line where there's different ways to express that could have been more demeaning.
Totally.
Right.
And I say this to my students all the time. I say, listen, you are going to encounter people and, things, ideas that run completely contrary to your belief system. And that's going to happen all the time with your students, with your teachers, whatever. But your job as a school leader is to protect the dignity and the rights of everybody, even and especially the people you don't agree with.
Right. Yeah. Because if the First Amendment only protects speech you like, it's not doing much.
Right.
Yeah.
Anyway.
I like that. Yeah. Because we got to protect LM's rights in the same way we've got to protect the dignity of our LGBTQ plus students.
Exactly.
Mm-hmm.
And that is a hard thing to do. Okay. I'm not.
Oh, for sure.
This is easier said than done. And I will be the first to admit that, right? It is really, really hard in many cases to protect LM's rights and protect the rights of the LGBTQ community. I maybe a better way to say it is it's really, really hard to protect the dignity of both groups, making them both feel heard and valued and understood and whatever.
Right.
That's a hard thing to do.
Mm-hmm.
But that's something we have to try to do.
That's the goal, right?
Right.
Yeah.
All right, sir. What's left?
Homework.
Okay. Tell us.
Speaking of more speech, your homework is to go out there and talk about Chalk and Gavel from the rooftops on social media. Visit our website, chalkandgavel.com. Share it with a friend, share it with a colleague, share it with your dentist. Maybe they'll enjoy this. I don't know. They went to dental school, right? But check out our merch at chalkandgavel.com. Also, a huge shout out to our new research assistant, Andrea Morris, for her help, because we need all the help we can get. Thank you so much for all the research support. And with that, I think that's all I've got.
Okay. Well, that's it for us. Have a great one, everybody. We'll see you again in 2 weeks.